One of South Africa's longest-running trials was about to reach its end. After years of delays, legal battles and public scrutiny, the verdict was finally here.
The state has not proved its case beyond reasonable doubt.
Yes. Quiet, please.
The accused are found not guilty and are discharged on all the charges. The court will adjourn.
All right.
The ruling was met with a mix of excitement by the televangelist's supporters, but for the greater public, outrage and unanswered questions. The case was marked by dramatic courtroom battles, allegations against prosecutors, and a judge's recusal. But in the end, the state failed to prove its case. To understand how it reached this point, we go back to where the 8-year legal battle began, on the 20th of April at the then Port Elizabeth International Airport.
It all began here at the then Port Elizabeth International Airport in April 2017. A dramatic arrest of televangelist Timothy Omotoso by the Hawks stunned bystanders and quickly dominated international headlines. Accused of a range of serious crimes, including human trafficking and the sexual exploitation of minors. But what followed was a legal saga that would stretch on for years.
The then 58-year-old pastor was intercepted moments after landing in the Eastern Cape, said to be meeting with his legal team after a warrant for his arrest was issued. For authorities, it was the end of a weeks-long manhunt. The arrest sent shockwaves through the country. As news broke, questions began to surface. How deep did the alleged crimes go, and how many young women were affected? Omotoso wasn't just a pastor, he was an international religious figure. His church, Jesus Dominion International, had a loyal following, a strong media presence, and branches across South Africa, Nigeria, and parts of Europe. To his supporters, he was a man of God, but authorities would soon allege that behind the pulpit and the sunglasses, a sinister story was unfolding. Soon after his arrest, more women came forward. Their statements described a pattern of grooming, manipulation, and alleged sexual abuse dating back years. Within days, the legal process kicked off. Omotoso was charged with multiple counts of rape, human trafficking, and racketeering. He was denied bail twice in 2017 due to multiple passports said to have been found in his possession. It emerged in court proceedings that he had a number of churches established in other countries around the world. Later that same year, 2 women were arrested and added as co-accused, Lusanda Sulani and Zukiswa Sito. The state alleged that they helped recruit young women, often under the guise of offering them roles in the church's music ministry. Together, the three have faced 63 charges. Sulani and Sito were granted bail of 2,000 rands each in 2017. And the woman who brought it all down? Community activist and whistleblower Pamela Mabini. Through her non-profit organization, the Maro Foundation, Mabini was instrumental in supporting victims and providing crucial information that led to Omotoso's arrest. Mabini was shot dead outside her home a month ago. Police are still investigating. What began as a dramatic arrest at an airport unfolded into a complex legal battle, raising critical questions about justice, faith, and the prosecution of vulnerable individuals. October 2018, The trial begins in the then Port Elizabeth High Court. In the witness box, Cheryl Zondi, just 22 at the time, becomes the first of several women expected to testify. Her explosive testimony gripped the country, but it was the aggressive cross-examination by defense advocate Peter Doberman that drew national outrage, with a mob even waiting for him outside court and throwing water and other objects at the attorney. Doberman's line of questioning was widely criticized as cruel and inappropriate. Judge Mandela Makaula was forced to step in several times to stop what many viewed as victim blaming. Months later, the defense uncovered that state witnesses had been housed at a guest house linked to Makaula's wife. The judge recused himself in March 2019 to avoid any perception of bias. The trial was stopped, a new judge was to be appointed, and the entire process would need to start from scratch. July 2019, after months of delay and the collapse of the first proceedings, a new trial began under Judge Irma Schoonman at the Port Elizabeth High Court. The same charges remained, but the process had to start over. For victims, this meant reliving traumatic experiences. Cheryl Zondi, who had already faced brutal cross-examination, would now return to the witness stand.
With the fact that Cheryl is going to go back to the stand, it shows that she knows exactly that what happened. It's not something that she's not lying. She tells the story exactly what happened, and she's willing to get in there and tell exactly what happened, the pain that she went through, so that the other girls, the other people, the other victims as well, can have confidence and go back there and tell exactly what happened.
Omotoso's supporters, on the other hand, were happy at what had transpired. And just a month after that, the defense raised new objections, this time challenging the structure and validity of the indictment itself.
They found out that there were a lot of manipulations. I mean, you cannot charge somebody, and the Constitution stipulates that the charge must be attached in the authority, and the charges were not attached.
But the National Prosecuting Authority held firm, arguing the indictment was valid and fit to proceed.
We maintain that, what is in the indictment is sufficient for them to prepare for the trial.
The challenge was dismissed, but it was just one of many legal hurdles still ahead. By late 2019, frustration was mounting. The indictment dispute, followed by arguments over jurisdiction, had pushed the trial into a standstill. The case would only return to court in early 2020. But just weeks after restarting, the country was gripped by the COVID-19 pandemic. Hearings stalled again, and for the one accused, still behind bars, another year in prison loomed with no trial in sight. In October 2020, a new legal strategy emerged. Late veteran advocate Terry Price filed a third bail application on behalf of Timothy Omotoso, citing unreasonable delays.
The case started in 2018, if I'm not mistaken, and so far they've only got through 1.5 witnesses. So, when you're talking about a case with 60-odd witnesses, that's really a tortoise slow,
But the state held its position. Prosecutors said Omotoso remained a flight risk. As a foreign national without travel documents, they argued he could disappear if released. The court agreed. Bail was denied again. By 2021, the delays were no longer just procedural. Accusations were mounting, this time directed at the state's own legal team. Lead prosecutors Nceba Ntelwa and Ismet Sarfontaine were accused of mismanaging the case, misleading the court, and even manipulating witness testimony. allegations that threatened to undermine the credibility of the entire trial. The defense claimed witness statements were being altered. During her final judgment, Irma Skuman laid out a series of troubling inconsistencies in how the prosecution handled key parts of the case, including the indictment and how witnesses were prepared.
It is appropriate to mention at this stage that Mr. Ntelwa, who was the lead prosecutor at the time, assured me that he had consulted with all the witnesses, for it seemed that he was not au fait with their evidence. He initially indicated that he was not going to apply for an amendment of the indictment, but he did bring such an application. It later transpired that the indictment served on the accused was not the same indictment that they were asked to plead to. This second indictment incorporates some of the amendments that was the subject matter of the application to amend. Advocate Ntelwa's superiors, Advocate Gobadon and Advocate Gounden, allowed Advocate Ntelwa to continue to prosecute the accused in the knowledge that Advocate Ntelwa had made the proposal referred to in paragraph A above. After an application in terms of the provisions of Section 174 of the CPA, 31 of the charges were dismissed as no evidence was led in respect of those charges. Furthermore, in respect of 2 other counts, I found that the witness Ms. Gianni's evidence could not be relied on, and those charges were dismissed as well. 11 complainants testified on behalf of the state, as well as 2 expert witnesses. After the application in terms of Section 174 was partly dismissed, a further application was brought to have the evidence of the complainants ruled inadmissible. This application was also dismissed.
At one stage, Ntelwa was removed and another prosecutor brought in. But without clear communication to the bench, Ntelwa quietly resumed his role despite questions over his handling of witness testimony. On the 2nd of April 2025, 8 years after his arrest, judgment was finally handed down in the trial of Timothy Omotoso and his 2 co-accused.
The cross-examination of the accused was desultory in the extreme. No thought went into it. The trial was set down for 9 days to deal with the evidence of the defense. Accused 1 testified for a whole day, setting out his defense, but the cross-examination of accused 1 lasted less than a morning session. He was not cross-examined on his denial with reference to the complainant's testimonies. No attempt was made to elicit inconsistencies or improbabilities. His cross-examination consisted mainly of putting a very limited synopsis of the respected complainant's evidence to him, which evidence the accused denied, then putting it to him that what they testified about is correct. It is not that there had been little scope for cross-examination. There was ample evidence that the veracity of his evidence could have been tested against. The cross-examination was shallow and lacking the intention to uncover the truth. Similarly ineffectual and superficial was the cross-examination of accused 2 and 3 that amounted to no cross-examination at all.
She pointed to serious failures in the way the state conducted its case, particularly the absence of meaningful cross-examination of the accused.
I cannot find that their evidence is incredible. However, I cannot find that the evidence of the accused falls to be rejected as false either. This is especially so as the accused evidence was not placed in dispute through proper cross-examination. When deciding whether the state has proved its case beyond reasonable doubt, this matter falls into the category where, in my view, the explanations of the accused are improbable, and I don't subjectively believe them. However, due to the uncertainty of the actions of the state and the lack of proper cross-examination, I cannot find that the accused version are so improbable that they cannot reasonably possibly be true. The accused bore no onus to convince the court of their innocence. I'm of the view, in the light of all the circumstances of the case, that the state has not proved its case beyond reasonable doubt.
Quiet, please.
The accused are found not guilty and are discharged on all the charges.
It was a verdict that sparked mixed reactions in and outside the courtroom. Timothy Omotoso, who had been in custody since 2017, spoke briefly following his release.
I thank God. I give him all praise. I am 67 by July, next July. I've been in prison for 8 years.
Outside, church members from Jesus Dominion International erupted in celebration. But for many who had followed the case in support of the victims, it was a devastating blow. The CRL Commission, which had backed the complainants throughout, laid the blame squarely at the feet of the National Prosecuting Authority.
The NPA let us down. The NPA let these witnesses down. There are hundreds, if not thousands, of victims out there who were waiting to see how this case goes.
For the Eastern Cape branch of the ANC Women's League, who had stood in solidarity with the complainants since the trial began, the ruling was both a legal conclusion and a moral defeat.
Because we are a constitutional country, that we must accept the judgment of the court, but we cannot run away to say that we are disappointed as Women's League, because this is what happens to the victims.
For Omotoso's supporters, the ruling was vindication. But for hundreds of women's rights advocates and survivors, it was betrayal of justice, of faith, and of the fight against gender-based violence. At the heart of the public anger stood one key institution, the National Prosecuting Authority. Under fire for how it handled this landmark case, NPA head Shamela Batohi responded with a firm public commitment.
This decision has a devastating impact on our fight in this country against sexual and gender-based violence. But more importantly, it has a devastating impact on the victims in this particular matter. And, we as the NPA will make sure, and me as the National Director, that we leave no stone unturned in trying to understand what led to the acquittal in this matter. But if there are any allegations that prosecutors are responsible for this, we actually make sure that there's investigations that are done in order to get to the bottom of it and ensure that there's accountability and consequences, whatever is necessary in the circumstance. These are highly emotional matters, and we must ensure that we get the facts and that we don't jump to conclusions without really making sure that we conduct the proper inquiries into what happened.
Batohi said the problems go deeper than one court and that her office is already taking action.
The conduct of the prosecutors with regard to what the judge said concerning lack of proper cross-examination, lack of skills with regard to understanding of definitions of rape, etc. So those are going to be an investigation from the National Office.
With the Ministry of Justice demanding answers, Batohi confirmed she had already engaged directly with government leaders.
As the National Director, I am equally outraged by the way this matter has panned out and the outcome in this matter. So I'm not surprised that the Minister has requested a report. I met with the Minister in Cape Town this week and verbally briefed her on it.
The judgment sparked outrage.
It needs to go beyond the NPA and actually say the investment, financial investment into public service is actually faltering. And as a result, the people who have got the duty to provide those services are compromised, and therefore compromising the people who are supposed to receive the services.
Women's rights organizations said the case raises serious questions about prosecutorial strategy.
The National Prosecuting Authority has got answers to give to South Africa on how this matter was handled. It's going to be very important for us to look at what evidence they had before them and why is it that they took less than 2 hours to cross-examine someone who we believed had committed heinous crimes.
What I would hope, though, is that this puts a spotlight on the NPA and that they tighten their belts in how they address GBV. We already know gender-based violence is a scourge in South Africa. So we need the NPA to ensure that they have the best people for the job at all times, ensure that the people with the relevant skills, to match up with the advocate who's coming on the other side are appointed in cases like this. This case is it wasn't an easy open and shut matter. The assaults happened way before the matter was actually brought before the court. And you can imagine this is now a person who's going through this all over again, having to testify before the courts.
From within the halls of faith, a different kind of reckoning.
This kind of judgment can also embolden faith leaders, unethical faith leaders, and other men who get the sense of that God is on their side. So it is really, really shocking. And I believe it needs to galvanize us as faith leaders, as our collective of faith leaders and so on, into real action, to also say to survivors, what these women have done is actually heroic and it is godly what they have done. We believe that the whole notion of proof beyond reasonable doubt is really problematic, particularly in cases of rape and sexual abuse and gender-based violence, which mostly take place in private. What standards need to be introduced that are survivor-centered, that protect the vulnerable, and that take into account the heavy responsibility on faith leaders in particular?
Some experts say the chances of a successful appeal are slim, but that doesn't mean there's no accountability.
What is different really about this case from other cases where we have seen the NPA appeal? It's where the court has really failed to protect. So maybe when the court has used rape myths, gender stereotype, and all of that. But in this case, this rebuke by the court is also a public lecture on the law of evidence, which really makes it hard for the NPA because she knows that there is interest from the public. And so she says, she goes into a lot of detail to explain what the NPA was supposed to have done and did not do, in this case.
Some experts say this case has exposed what has become a pattern in the NPA.
Is what happens to many other rape cases that never ever make a headline and never make it to social media. Because I think what we are seeing here is a decade's worth of decline in the prosecuting authority. If you look at 2013-14, they were able to put down more than 8,000 rapes for prosecution. In the last financial year, that had dropped to 5,200. So this is a decline in performance. What we've seen in the Omotoso case is, I think, a very public representation of it, but it's not exceptional and it's not unique. And it's an urgent call to understand what is going wrong from the moment of reporting all the way through to the point of conviction.
As pressure mounts on the National Prosecuting Authority, government leaders say the outcome of this case cannot go unanswered.
The minister has given the NDPP up until Monday the 7th to receive a report from them. I wouldn't want to comment on the steps that will happen immediately afterwards. We'll have to study the report first, and then we'll announce action or a way forward after studying the report.
With questions swirling around the possibility of a fresh legal process, the Justice Department is not ruling out further action.
We would encourage them to try and keep Mr. Omotoso in the country. It will be in the interest of the country to keep him here if they intend to bring him back to the system, if they intend to follow the right procedures to appeal and maybe make him stand trial again or face the justice system again.
Parliament's Justice Portfolio Committee has also weighed in, calling for deeper scrutiny of the prosecution's performance and broader institutional accountability.
We are in full support of the Minister's invocation of Section 33. She is the final authority on prosecution, and as such, the NPA Act gives her powers to request a report on any case. In this case, we believe that it justifies her invoking that particular section. You will note that this is not the first case where the poor performance of prosecutors has been raised. The case was not lost purely because the accused was truthful, or was it lost because the victims were not entirely truthful? It was lost on the basis that the NPA performed poorly, and the judge characterizes the cross-examination as lacking intent to extract the truth.
A complex trial, a controversial judgment, and a nation still asking questions.
8 years, dozens of court appearances, and countless legal delays later, the trial of Timothy Omotoso ended in a full acquittal. The judge sharply criticized the conduct of the prosecution, questioning not just the handling of evidence, but the fairness of the process itself. For the accused, it marked vindication. But for many South Africans, it left behind a trail of unanswered questions and a justice system under scrutiny. For Newzroom Afrika on Channel 405, I'm Sipha Kema in Gqeberha.